And I'm going to read out this argument that was raised. The state, as far as remember, one of the major allegations by the ED and the CBI has been that this evidence was destroyed that Mr. Sisodia had changed his phone 12 times. What Dayan Krishnan is arguing is that as far as the phone is concerned, the allegation is that I changed the phone when the policy document went to the LG. Dayan Krishnan, as the defense lawyer, is asking exactly what does that really show? Where is the evidence to prove that there was anything on the phone that was changed or thrown out? He's also saying that why is there such haste in starting the inquiry and suddenly arresting him when nothing was done since 2022, when the investigation had initially begun. Now, what Dayan Krishnan has also said is that while the ED does have wide powers of investigation, of arrest, of detention, of seizure, they have, and there are restrictive bail conditions under the PMLA. According to Mr. Krishnan, this is being done specifically to ensure that Sisodia does not come out of jail. And one of the arguments that he's made, that my colleague Srishti has highlighted also, is that Sisodia's counsel is arguing that the burden is not only heavy on the prosecution, but also on the court to ensure that there is fairness when it comes to issues like this. And they are saying that there is no evidence whatsoever of money laundering specifically. The money trail has not been found by by the Enforcement Directorate, and that is why the agency, which is supposed to be looking at the money trail, has only been talking about the change in policy, the destruction of evidence, the meetings between various persons, etc., but have not specifically mentioned the money trail. And that is why Sisodia's lawyers are saying that it is for the court to ensure that agencies are not used in this malified manner only to keep a man in continued custody. Now, further investigation, further argument, I beg your pardon, is going on inside the court. Dayan Krishnan has concluded his line of argument. Now, Senior Advocate Mohit Mathur, who is the second senior advocate appearing for Manish Sisodia, he has started his line of argument on the requirement to curtail somebody's liberty and freedom. He is saying that under the requirements of Article 19, the requirements of Article 21 mean that there has to be specific reasons to keep somebody under arrest. That Mr. Mathur is also in fact arguing, and I'm reading out what my colleague Kanu has sent us, that it is only a fashion with the investigating agency, and time has come when courts have to be very strict with the agencies so that the agencies also know that they too are answerable to the law. And that is very clearly the line of argument that is being taken by the lawyers of Manish Sisodia, who are saying that the ED has not brought any direct evidence against Sisodia. The ED is only talking about the allegations of policy change. The ED is only talking about the allegations of meetings. But what they are saying is that policy change is the domain of the executive government. Just because a policy was passed quickly, you cannot say that it is per se indication of corruption or any sort of money laundering. What they are saying is, bring us the proof. Where is the actual proof of money laundering or any sort of malified actions? They're also arguing that, this is Mr. Mathur's argument that is continuing right now, that courts must come down heavily on the entitlement that these agencies seem to feel regarding their power to arrest. Just because the power to arrest exists effectively, that is the argument given by Sisodia's lawyers, just because the ED has been given extensive powers of arrest, detention, seizure, etc., that does not mean that they can misuse those powers, because again and again they are simply asking that when you say there is a money trail that is being investigated, where is the money? Who has got the money? What proof do you have that Sisodia was ever involved in anything to do with the money? Because remember, while Sisodia's name has been taken by witnesses, by co-accused, what the defense argument is saying is that this is all hearsay evidence. Just because somebody claims to have heard Sisodia say something, that does not mean that it will be taken as actual proof. Remember, the ED's argument, and we've been discussing this for a while now, the ED in its arguments had said that Manish Sisodia's own secretary has said that he was there in the meeting where Sisodia said that the policy needs to be changed, that directions were given to him to change the policy document. Now, that is where this line of argument by Sisodia's lawyers comes in, that simply because one person is claiming to have heard this does not mean that it was true, because the policy document itself, the file notings themselves do not indicate this at all. Now, if the file noting was changed, if there was any change in the policy that was brought in without the expert committee recommendations or without the GOM recommendations, there has to be something on paper, there has something to be that some sort of documentary or evidentiary proof, and you cannot rely only on the statement of official or a co-accused to say that this is at the gospel truth. That is the argument, line of argument that is being taken by the lawyers appearing for Manish Sisodia, who are saying repeatedly that they are questioning the ED's bona fides. They are saying that the ED is acting in a malified manner, and they are questioning the power of the ED to seek remand like this, because ultimately, according to the senior lawyers appearing for Manish Sisodia, it is the responsibility of the court to ensure that the investigation and trial is done in a fair manner. So effectively, Nabila, in the last hour plus that we've been discussing this entire issue, the ED has been talking about meetings undertaken by Sisodia. The ED has been talking about how they have witnesses saying that Sisodia is the person who ordered the officials to change the policy, that Sisodia is the person who basically decided that the policy should be changed so that some sort of benefit should be given to the South cartel, that Sisodia and Vijay Nair were responsible for getting files pushed through. What Sisodia's lawyers, on the other hand, are arguing that just because somebody said that this is how it happened does not mean that you have actual proof of it happening. It does not also mean that you have found any sort of a money trail, and that is where, and this is a question that you had also asked me, that is there any proof of the money trail that is being talked about by the ED, and so far the ED had said that that some money had come from Hyderabad to Delhi, that there was a political understanding involved, that in fact they've quoted certain co-accused and the approver in the case, and and those statements are being opposed by Sisodia's lawyers, who are saying that these are policies that are created by the government. It is not for somebody to say whether the policy was right or not. Just because someone some sort of policy was changed does not mean that this is there was any sort of corruption.